Sir James.
Well, my lady, thank you very much to Mr. Sheck for directing me in wizardry rather than do it for myself. I'm hoping that's a little bit better and a bit less echoey, but anyway,
It's fine. Thank you very much.
I'm grateful. The third point I was going to make in terms of the stage of the argument is that section 2.3 plainly has, we submit, some extraterritorial reach. And if I can invite you to take up the Divisional Court's judgment in relation to that, at paragraph 64, electronic page 135, we respectfully adopt and endorse their reasoning in paragraph 64 on this point. It's simply, in a nutshell, not credible to say that a UK company, to take that example, operating here but with email servers abroad, could resist production on the basis that the documents are held abroad. And if that's right, what one's actually dealing with is the extent of extraterritoriality and the implicit limits on the breadth of the words used by Parliament, which do carry with them some extraterritoriality. Of course, it's definitional based, but that's the reasoning which we respectfully adopt. And there's either a power to operate the section when and if you have this combination, or not. But you submit that that's a key stage in the argument, as the Divisional Court recognised and found in paragraph 64. The fourth point is that Parliament has built in protection which would operate to protect against notices that might give rise, for example, to local, foreign, legal or practical difficulties. There is, of course, the discretion, the fact that it's a discretion, not a duty under our domestic scheme of legislation. But Parliament has gone further and has provided a defence if there is a reasonable excuse for non-compliance with the notice. That's an integral part of the scheme, so that if, for example, there was a problem with production under local law, or more generally, if, as it were, unreasonable action were required abroad, then that defence is potentially applicable. And the existence of safeguards is an integral part of the statutory scheme. Again, as the Divisional Court recognised and took into account, see paragraph 73 of the judgment on pages 138 to 139. The fifth point is that we submit that the limits that my learned friend suggests to the jurisdictional reach are highly unlikely, we submit, to have been intended by Parliament. It appears to focus on the corporate limit, first of all, to be related to the place of incorporation, a foreign company. But incorporation alone provides, as I described it earlier, an adventitious limit, having regard to the nature of this sort of scheme. What, for example, if you had a company that happened to be formally incorporated abroad, but it operated out of London for all relevant purposes? There's nothing to suggest that the place of business is part of this statutory scheme, but it opens up all sorts of debatable inquiries about it. A person, as defined in the Interpretation Act, is corporate or unincorporate. No suggestion of business presence or anything like that. But the fundamental problem remains, what if you had full-blown connection with London or degrees of connection with London? And it can't depend on whether the foreign company has registered a branch in the UK or entered into other formalities, such as nominating a person for service in the UK. That would, might be thought, create an incentive for companies that don't want to be liable to provide those documents to choose particular business models. And similarly, if you sought to impose a carrying on business as a requirement, you end up with similar questions. The intention, we submit, of section 2.3, particularly when read alongside section 447 of the Companies Act, was to provide as broad a reach as possible without, if I can put it this way, because this is always implicit, sovereign exorbitance. So we respectfully submit that mere incorporation in place of incorporation is a very unlikely intention. The second one, limitation, relates to the location of the documents. That itself is hard to limit, to square as a principled limitation, given that it wouldn't operate on any view, as Millennium Friend appears to accept, for a UK company which happened to have documents abroad. And in any event, it's hard to see why it should make all the difference jurisdictionally. The company can call for them if it's in their power to do so. And the physical location doesn't impinge on another state's sovereignty. We discussed earlier on the vicissitudes of servers and where documents might be located. And I made the point that that too is to some extent infinitely variable and adventitious. There is, if you're interested in the question where a document's held, where electronic documents held, emails, for example, there's some analysis. I don't invite you to turn it up now, but just by way of information, there's some analysis of that in the Microsoft decision to which Lord Panic referred. Just give you the page numbers, 1229 to 1230. In effect concluding that emails held on overseas servers are held abroad, even if presumably accessible from London. But if that's not, even if that's not right, if they are accessible from the UK and that's the location of the documents, because you can access them, say, from the UK, then you haven't got a problem with extraterritoriality at all. So we do submit that both of the elements that Millennium Friend puts forward as principled controls on jurisdictional limit, in fact, cannot sensibly operate in that way. They risk being unworkable. They are adventitious having regard to the nature of the issue, which is jurisdictional. And they would risk, if Millennium Friend is right, undermining the effectiveness of the investigative power, which on any view Parliament was very concerned to ensure in this short piece of legislation. The sixth point follows on from that, and I express it, if I may, in this way. It may well be that this issue was to some extent dropped away, or to a significant extent dropped away as a result of Millennium Friend's helpful submissions this morning. But the proposition is that there are no insuperable or clear international legal objections to the operation of Section 2(3) in this case. And you will remember that in this case, notice was given to a representative of the foreign company who was here. Miss Ackerson was General Counsel of KBR. She was given the notice in the UK when she was here on behalf of KBR Inc., and there's no appeal against that conclusion. The Divisional Court held at paragraph 99 sub 2 that as a matter of fact, Miss Ackerson was in the UK representing KBR Inc. As they put it, she was not here coincidentally or on some personal frolic. The notice was therefore given to KBR Inc. in the jurisdiction. There's no appeal against the way the notice was given. And shortness of presence of an that's in the UK has never been an issue in terms of jurisdiction over that person. What is being done is essentially to erect a special rule for foreign companies. But Section 2(3) doesn't provide special rules for compliance by companies. And it's hardly likely that Parliament would have intended that. There is here no question of performing any official act on foreign soil. You're not entering premises, you're not searching. And it matters not, as it mattered not in Jimenez, that there exist powers in 2(4) and 2(5) to issue search warrants which will be restricted to the UK. They're simply separate powers. And so in those circumstances, against that backdrop, with the important fact on which the divisional court placed significant reliance, not least in relation to distinguishing Perry, the notice is in fact served on KBR in this jurisdiction given to them here. And we do submit more broadly that much of the reasoning of Lord Justice Leggett, as he then was, in Jimenez, who's particularly dealt with the international legal issues, is very powerful and relevant here, focusing principally, as it does, on the operation and effect of enforcement jurisdiction, as it's called, under international law. We've given you the key paragraphs in our case at paragraph 37. If you want it in the raw, it's behind tab 16, page 720. But you wouldn't be enforcing in the US. You'd be enforcing here, if at all. So that's the backdrop against which the international legal issues arise. But my learned friend has positively asserted this morning, in the context of the Perry case, that he does not seek to suggest that there would be an international legal difficulty with giving section 2.3 the reach which the SFO contends for. And that is both correct and highly significant, we submit. It's highly significant, not least because you will recall paragraph 94 of Perry. I'll come back to that in a second, but just to note, we submit that the divisional court was right in any event to distinguish Perry for the reasons it did in paragraph 76 of the judgment. Different legislation, fraud context critical, real potential to undermine the operation of this specialist regime, not present or anything like as stark in form in Perry. Here, critically, the person is present in the UK when given the notice. There were a series of correct connections to which I will come between KBR Inc. and this jurisdiction. See in particular paragraphs 81 to 83 of the divisional court's judgment. Contrast Perry, where there was no connection to the UK at all. So the degree of extraterritoriality is much more limited in our case. And if there's an assertion of sovereignty, it's much more limited in relation to the collation of material abroad only. It's very surprising if Parliament wasn't content with that. As I say, critically, Perry was about sending a disclosure order to someone overseas. And the problem, as I well recall, in Perry, was the perpetual example of the Peking thief operating in Peking and only in Peking, living in Peking, who'd never been to England or anywhere near it. He lived in Peking. So I was beaten repeatedly with that example, which there wasn't really a terribly good answer in that context. Here we have, by contrast, something very different. And you see that feature feeding through even into Lord Phillips's analysis. So the bounce is between paragraph 94 of Lord Phillips and the conclusion and description of the issue and his conclusion in relation to the issue in paragraph 98, which is all about sending the notice abroad. We didn't do that here. Here, KBR Inc. was served, as is uncontentious, and properly served with the notice here. But I come back to the base point. It is absolutely critical to the reasoning of the Supreme Court in Perry that there was an international legal issue of the most significant kind. A clear and serious breach, as it was put in paragraph 94, on the basis of a perceived international legal principle of the kind set out in paragraph 94. My lady, I'm sorry. Yes. You're muted, my lady. I'm so sorry.
If I could just ask you a question. Lord Panic was careful to say it was comity, not international law, as you have developed. And that means that he's relying on a body of practice which is not legally binding, as I understand.
Yes.
That it might achieve the status of legally binding through becoming customary international law, but that's not been suggested. So if one's looking at comity, then could I ask you about the presumption of interpretation which we're looking at? Does it have the same resonance if it's a matter of comity rather than international law? Because Lord Panic argues, well, Parliament would be keen to ensure that comity is also observed, so the same courtesies are extended to British citizens when the foreign courts are making the equivalent orders. Would want to ensure that comity was observed for their benefit, and that's good for the UK, and therefore there's a public interest in ensuring compliance with comity. Or is that simply something we can't judge because it's too uncertain? Comity is too uncertain, doesn't have fixed boundaries, and isn't legally binding. I'd just like some help on that, where the presumption takes us. Thank you.
My lady, my answer, you won't be surprised to hear, is that it's a fundamentally different beast. If you have an international legal rule or principle, whether derived from treaty or, as my lady points out, from customary international law, where the rules have hardened and you have all the requirements that precede customary international law being formed, that's one thing. And you can, as it were, presume that Parliament will not unambiguously legislate against that. It is, if you will, the flip side of the same coin that says that one of the legitimate domestic legal uses for international law is in the interpretation of ambiguous legislation. That is one thing. Comity is quite another. Comity is a much more flexible beast. It's a much more uncertain beast. It doesn't have anything like the solidity or force of international law in any of its forms. And it is extraordinarily difficult to work out what Parliament might do or not do in relation to that looser form of international cooperation and respect. I mean, to the point where you can ask the question in very concrete terms in relation to this legislation. The premise for my learned friend's submissions on comity were very much, wouldn't it be a disaster if the same applied in our direction? Well, sometimes that works. One thinks of international legal instruments such as the diplomatic or the Vienna Convention on Diplomatic Relations. If we treat foreign diplomats in London in a particular way, for the purposes of, say, an immunity, the real concern is if you do it that way in London, then British diplomats are suddenly going to be not given immunity in Peking. Or if you allow premises to be searched here, whatever it may be. So you can have some situations in which international law and reciprocity provide powerful incentives, but far less clear in a context like this, where if effectively the same rule in reverse would simply have a jurisdiction like the United States able to impose on British companies whose executives were present in the United States, as it were, a bit like Miss Ackerson here. They could be served with a notice by the DOJ or the SEC saying, produce documents subject to sanction. So it's a much less strong thing.
I believe the American approach is considered not to violate international law from their perspective of American law, on the basis that the state can legislate to protect itself and its integrity. So I shouldn't. Obviously, that's not necessarily the view here, but it does expose the fact that international law in this area is not very easy. It may be quite confusing. But another confusing factor is that you've emphasized the context, but the context here is of international cooperation, of all these mutual legal assistance conventions being formed. And so one would suppose that perhaps comity was in Parliament's mind at some point in this story.
My lady, to some extent, yes, and I accept that. Of course, some MLAs have been signed up. I'm going to come back to MLAs as a specific topic, but you will, just to flag up one point at this stage in answer to my lady's question, I think the divisional court judgment indicates that in relation to America, the first of the relevant MLAs that we are concerned with was signed in 1994. In other words, some considerable period after 1987. Leave aside all the fact that MLAs only cover some countries for some purposes. Leave aside the practical difficulties that arise in relation to those. So I can, of course, accept that to some extent comity might well have been in the minds of Parliament. But the question ultimately is not whether comity was in their mind, but whether or not they intended that in 1987 particularly, less formed international instruments of legal cooperation such as MLA were intended in 1987 to be the exclusive mechanism by which the effectiveness of the investigation could be protected. I come back, I don't want to stray too far from the Perry point at the moment. I mean, the Perry point is that the divisional court found that Perry could be distinguished, even taking 94 of Perry as correct and at face value. And my learned friend no longer contends, or does not contend, that it would be contrary to international law to do the thing that the Supreme Court said it would be contrary to international law to do in paragraph 94. He puts it on the basis of comity. And that is important because it was fundamental to the reasoning of the Supreme Court in Perry that the court had discerned a clear international legal principle, which it said would clearly be breached. That was integral to its approach to the interpretation in that case. My Lord Stevens. I'm not sure someone's unmuted you quite yet.
Thank you. I was just wondering whether you accept that making it a crime in a foreign country in relation to a foreign national is a breach of international comity. And if you do, then you just change the wording in paragraph 94 of Perry from international law to international comity. So do you accept that it is a breach of international comity?
I don't. I don't, because you can, as I indicated earlier, by reference to the Bribery Act as one example, prosecute if part of the offence occurs in England.
But that is Parliament deciding to do so. But as a matter of legal principle, it would be a breach of international comity. The Parliament may take the risk. Parliament may decide to do it. But we're not Parliament. We don't decide between the diplomatic on the one hand and the public interest in getting hold of documents on the other. That's for Parliament to do.
Well, my Lord, that's what we're debating. We say Parliament has done it in section 2.3 by setting it up in this form.
And so therefore paragraph 94 of Perry is wrong, is that right?
Well, my Lord, we're pretty close to a position where it's accepted to be wrong.
Right. So
in terms at least of an international legal principle as compared to comity.
And so we should depart from that judgment.
My Lord, you don't need to, because there are grounds for distinguishing Perry of all the kinds that the divisional court put forward and which we respectfully adopt and agree with. But we do suggest that it is significant that what was said to be a fundamental international legal principle is now being presented on the basis that it is a matter of comity. And we do urge a little caution. I mean, we haven't needed to go here in this case, but we do urge a little caution with the breadth of the proposition of principle in paragraph 94. As I'm not going to go through them, but it is perhaps worth examining with a little care, if you do get into that territory, what the submissions actually were, which appear to have been accepted in 94, and the disparate international legal principles that were being advanced, rather than the single global principle which one sees put forward in paragraph 94. The arguments of principle are set out in the electronic bundle at 576 to 577. But some of the cases that are relied upon for various parts of those principles are based on enforcing foreign judgments against foreign assets. Some of them are to do with conduct of searches in a foreign state, which would obviously be a breach, but hasn't got anything to do with the principle which is then set out. Some of them are to do with service of civil proceedings outside the jurisdiction, and again don't support the kind of breadth of principle which is being advanced there. And in terms of the legal position and prosecution of conduct abroad within this jurisdiction, we sent overnight, I think, the extract from Archbold, which perhaps I don't need to get you to take up now, but there's a paragraph in there which explains the true position in relation to the nature of conduct occurring. Some part of the conduct only needs to occur in the United Kingdom, which obviously here it would do, given the notice here, compliance is required here, and so on. So we're dealing with a hybrid situation. We're not dealing with the clarity of everything happening abroad that they were dealing with in Perry, but the case on which it might be thought some reliance might be placed in terms of demonstrating that as a basic common law approach and principle to English law is in the second subparagraph of 2.36 of Archbold, the Smith and Wallace Duncan number 4 case. But it is significant, however much you take that principle as read, and whether you call it comity, whether you accept the principle at its full breadth, or whether you take it as a lesser beast, as perhaps might be more cautious, whatever the position may be, the fact of the matter is that here we are dealing with a situation where you've got, if I can put it this way, blended behaviour. You've got the notice being given here, you've got the compliance required here, you've got some presence in the UK through General Counsel, activities being conducted, as it were, through the agency of the UK subsidiary, and so that we submit is a very different situation to the situation that inured and existed in Perry. But as I say, we take comfort from the fact that the case is now being put on the basis that it's comity rather than some clear breach of an international legal principle that could or would be applicable to our set of facts. Lord Briggs.
You said a moment ago, when responding to Lord Stevens, that this is a case where the notice is given here, undoubtedly true, and compliance was required here. Now, I can quite see that if the foreign corporation had a branch, or a fortiori its main office here, then even though the documents were located abroad, it might be said that it could comply with the requirement here by giving an instruction here to whoever is looking after its documents abroad to repatriate them, so that there would be no international cross-border element arising out of compliance with the demand. But and I can see that there will be many cases where that may be so, where the respondent to the demand is a corporation and it operates its affairs in such a way that there is someone here who can give the necessary instruction. It may not just be where a single company has a branch here, but where a parent has a subsidiary here, if the document relates to the activities of the subsidiary, and the subsidiary is entitled to have that document. But in this case, the only reason why Inc. was here in any sense was that a senior representative of Inc. had come to attend a meeting to discuss the matter and was presumably going to take the next flight back before or after a trip to Harrods. And it just seems to me that on the facts, the proposition that compliance with this demand was taking place here doesn't really stack up, and that the test, where has compliance got to take place, might be the best possible expression of the notion that this shouldn't be construed as having extraterritorial effect.
Well, my lord,
Long question.
No, don't worry. When a notice is given, it's given to an individual to whom you are entitled to give the notice. And no one disagrees with the proposition.
No.
We're entitled to give the notice to KBR through the authorised person who was present here. True it is they were here on a temporary basis, but no one knows where the relevant documents relating to the Treasury function are or may be located. I don't know. I mean, neither does the SFO. So it is entirely possible for the person who is given the notice, given that the SFO doesn't know where the documents are, to call for the documents whilst in England. And in those circumstances, there would and could be compliance here. But true it may be that in some cases you have totally fleeting presence, as it were. They're literally tapped on the shoulder on the way through Heathrow, in which case the question would be a broader one. But the more general point perhaps is that these sorts of distinctions need to be judged in terms of their coherence as providing jurisdictional limits against the context which we're dealing with. The investigation of crime. Can it really be the position that Parliament intended that the jurisdictional limit should be provided on the basis that someone was here for 48 hours or less, or that they were operating in terms of the corrupt activity that was being investigated essentially through the UK subsidiary with just the Treasury function farmed out to America? It just doesn't provide a coherent attribution of intention to Parliament in terms of the reach of this legislation. And it may well be that lots of technical rules exist in relation to the service of civil proceedings, and we know that there are lots of complications in relation to that. But here we're dealing with a mechanism which Parliament, if it intended nothing else, must have intended would support the investigation of inter alia transnational crime of this kind.
Yes, thank you.
Just to turn, if I may, to some responsive points in relation to the submissions that have been made. My learned friend relied on the DTI powers. Sorry, I'm just being sent a missive saying that the notice itself is at EF, the electronic files, page 249, and requires the provision to the SFO at their London address of documents. I'm not sure whether that takes this debate much further, but just a matter of notice and where strict compliance is required, but that at least you might note. Millennium Friend relied on DTI powers under the Companies Act, requiring production of books exercisable in relation to foreign companies, provided they carry on business in the UK. You have those provisions at Bundle 1 of the Authorities, Tab 1 and Tab 2, starting at page 321. Don't invite you to turn them up now, but the short answer to any suggestion that one can infer, leaving aside Roskill, which said you better have the same powers if you're a prosecutor investigating, you better have the same powers as at least as company inspectors have. The short answer to any suggestion that you can infer from the absence of similar wording that there was an intent to restrict the operation to UK companies, that's presumably UK incorporated companies only, is the one given by the Divisional Court at paragraph 67 on page 136 of the electronic bundle, which is that it's highly improbable that Parliament would have intended, especially having regard to the context, that the SFO should have more limited powers in relation to foreign companies than those available to DTI inspectors. I say we leave aside Roskill. If Roskill was clear about one thing, he was clear about the fact that the position in relation to investigating fraud must be a fortiori. So we respectfully submit that nothing is to be derived from 447 other than the point which is favourable to us and helpful to us, set out in the judgment at paragraph 67. So far as the parliamentary materials are concerned, on which my learned friend most of
Sorry.
the weight. I'm so sorry, my lord.
Sorry, no, not at all. I was just wondering, on my reading of it, the statutory principle of interpretation is whether the enactment applies to all persons and matters within the territory. And accordingly, if a company carried on business within the territory, the enactment would apply to them. It would then be a matter of discretion as to whether or not to make an order. So if the order, give a notice, if the notice was in relation to totally extraneous matter, for instance, activities in the Bahamas that got absolutely nothing to do with the investigation or nothing to do with the activities of the company within the jurisdiction. But I don't perceive Section 2.3 as not applying to exactly the same group as the DTI powers apply to. That is a company a foreign company carrying on business within the jurisdiction.
Well, my lord, takes us on to at least aspects of the sufficient connection test and how you define a sufficient connection, which I'm going to come to at the end. But I can, for the purpose of the argument we're on here, which is jurisdiction, I can perfectly contentedly accept that because you have to introduce another condition to the one that my learned friend was contending for, which is if you're foreign incorporated, it's out. You're without the jurisdiction. But even if something of that ilk comes back, whether that's part of the sufficient connection test or as a matter of interpretation, because you read it in the same way as 447, may not matter quite so much for present purposes.
I read it as the law applying to a company that's present in the United Kingdom. And presence can be interpreted in a whole series of ways. It doesn't depend upon incorporation. It can depend upon a whole series of things. And so I don't see why the power doesn't apply to a foreign company that's been carrying on business within the jurisdiction. But this isn't that case. This company wasn't carrying on business in the jurisdiction, and the documents are held in the United States of America.
My lord, that's true. You know that my case is that it's broader than that, and that any person includes any company, whether it's a foreign company, whether it's not a foreign company. There isn't, and perhaps advisedly isn't, having regard to the 447 precedent, there advisedly isn't the same restriction as you see in 447. That's my short answer to that.
If I could just add to Lord Stephen's example, Section 447 may be mainly about the investigation of business. Here we're talking about the investigation of serious fraud, and it would seem to me not to offend the extraterritoriality principle to construe Section 2.3 as extending to a company, for example, which was being managed within the jurisdiction, even if the main business activities were mainly elsewhere and it was incorporated elsewhere. But that would still be an aspect of presence, which would mean that a company of that type could properly be sent one of these notices.
But
not least because the managerial step required to comply with the demand would, under that analysis, take place here.
But even if you do end up with
if something in a foreign place had to go and comply with the demand.
Yeah, you do end up with a very serious disconnect then with the basic purpose of the provision, which is to assist the SFO to investigate transnational, inter alia transnational fraud. You could have precisely the situation which exists here. Both of my lords have put to me situations in which the reach of the section to foreign companies is curtailed and conditioned by the foreign companies carrying on to a greater or lesser degree business in the UK. But here you have a situation in which the company itself, the foreign company itself, might not carry on itself routine business here in the sense of, for example, entering into corrupt contracts. But nevertheless, a critical part of the investigation of this crime is to work out how the money flows work, what the invoices were for, who approved them inter alia for the purpose of working out whether the foreign company itself should be prosecuted, or individuals within the foreign company should be prosecuted. So you've got a series of carrying on business, you've got a series of functions that are being performed that are critical to the criminal investigation. But it just so happens that the foreign company does not do the act of entering into the contract with the crooked agent or the person who is going to be providing the oil to be extracted, or whatever it may be. So I think my respectful submission in answer to both of my lords is that the true extent on which you build up a limitation when you're dealing with a foreign company should be directed to the fraud, to the thing that is being investigated. And Parliament's intention must have been to make that investigation effective. And if you do it on the basis of the sorts of rules that no doubt have sway in the civil context, where you're trying to find the seat of a business for working out generally whether it's got a connection with the jurisdiction, that is not a useful or true or valid comparator. That what you should be doing is to focus on the fraud, and this case is a pretty good example of that. I mean, you can build it up further. Suppose the foreign company is actually committing the fraud by, I don't know, directing people to sign crooked agreements in the United Kingdom, but nevertheless the bulk of its business it takes place abroad. It would be very strange indeed, we submit, if that were to fall outside, or as a matter of interpretation, if you were to corral foreign company in that way, so as to exclude precisely the sort of situations here where they desperately need to find out how the money flows worked, who was doing the treasury function, who was authorizing the invoices, and that it just so happens was being conducted in America by Inc., even though the contracting party and the notional paying party is the UK company, in fact conducting business in the UK. Well, so that's how we put it. I see the temptation, but I respectfully submit it's a temptation that flows from analogies, as it were, with a civil approach. And here we're trying to discern the intention of Parliament in relation to the criminal statute. I've probably said enough about those points. I was dealing with the suggestion by Lord Panic that later provisions and other provisions and ministerial statements indicate that MLA is the root. That was essentially the thrust of it. And the short answer to that, we respectfully submit, is that the later provisions are permissive, and they are explicable as creations of legislative power, because in each of the examples that we've seen, the legislative power was necessary, and obviously necessary, to enable the SFO to react. But they are not indications in any shape or form of a parliamentary intention that MLA should be the exclusive means by which this sort of information could be gathered, so as to cut down section 2(3) in that way. And we submit that paragraph 93, albeit in a slightly different part of the judgment, but bearing on this point, paragraph 93 of the Divisional Court's judgment it is in this respect entirely correct, describing the MLA processes and powers as additional, their emphasis, powers, additional to section 2(3). You will also note under that headline point, and without prejudice to it, a series of points in relation to the disparate people to which you were taken. The 1990 legislation it's to be borne in mind, is not merely permissive, but it applies to the wide range of investigators and prosecutors. You're not dealing with the specialist context that we are dealing with, that I outlined at the beginning, that the SFO operates in. That's the 1990 legislation. It's entirely unsurprising, we submit, that the 1987 Act was amended to confer the powers that my learned friend relied upon to export information. In other words, when an MLA request comes in pursuant to one of these agreements from a foreign set of authorities, because you would need domestic power for that purpose. Otherwise, they'd be accused of acting beyond the scope of their statutory remit, and they're a body set up by Parliament, and so they exist like a local authority, and their powers are contained within legislation. So you need that additional power in relation to export. It's perhaps of some significance that it's not dealing, brackets, we say because it didn't need to, with the importing of information, because they already had the power to do that under section 2.3, if that isn't too self-serving a point. But the export power plainly was needed as a matter of domestic law, because otherwise someone would say that responding to an executive request by a statutory body was ultra vires. There's nothing either in terms of the reach of section 2.3 to be read into the change to the 1987 Act in new section 2 capital A. The fundamental and basic purpose in relation to 2 capital A was to broaden, not shrink, the powers of the FSA, so that they were able to make these sorts of requests at the pre-investigation stage. In other words, prior to launching the investigation. That was why 2A was introduced. And the fundamental point in relation to all of those pieces of legislation is that Lord Roskill was entirely clear that whatever else they needed equivalent powers to the powers that were being conferred or had been conferred on company inspectors. Any person was the way in which Parliament chose to do that, without the limitation that you saw in 447, without wishing to reopen the debate I had with Lord Stevens and Lord Briggs a few minutes back. I should say we have some considerable concern about Lord Pannick's rather blithe assertion that you can simply rely on ministerial statements of this kind for the purpose he sought to rely upon them for. We're not, in truth, construing or interpreting ambiguous legislation. But the suggestion appeared to be that the ministerial statements were or could be taken as being premised on a certain understanding of the pre-existing legal position and or the position as it existed as a matter of comity. He no longer says international law, but as a matter of comity. Well, a ministerial submission or a ministerial statement to Parliament may be based on an understanding of comity, which is good, bad, or indifferent. It would be equally objectionable for me to start trying to rely upon an inferred understanding of what comity entailed, were those statements to be the other way around, and to say, oh, it's absolutely clear they can go off and do this. So we do urge considerable caution before relying upon ministerial statements of that kind for this purpose. But more fundamentally, we submit that the legislative provisions which my learned friend sought to rely upon, and indeed Lord Roskill, which he sought to rely upon, as supporting a proposition that Parliament always, as it were, set its face against a 2-3 power of the kind we contend for, and in favour of MLA, simply doesn't wash, it doesn't start, because you have to say, for that to be a tenable contention, that you can infer a parliamentary intention that that should be the exclusive way. And the answer to that was given in paragraph 93 of the Divisional Court's judgment. This is an additional power. Why should that be so? Well, again, that was the subject of some serious consideration by the Divisional Court. There is no doubt that there is power to issue letters of request and that MLAs can be a necessary and useful adjunct to the sort of broader powers which we are considering. But they do not operate, we submit, to limit the ability to obtain the powers in any other way. There is good authority in the criminal context. I don't invite you to turn it up, but we've cited it in our case. The authority is Redmond, the Queen and Redmond, page 1167 to 1168, at paragraphs 23 to 25, which makes it absolutely clear that in principle, MLA powers to obtain evidence abroad are powers, not exclusive obligations. And there may be very serious issues with simply relying on MLA as the exclusive tool, or indeed in some cases as even a remotely effective or available tool. To start with the lightest of the problems, perhaps, documents on the cloud held on multiple servers. What do? Do you do MLA requests to every state in which the servers are located? How does all that work? There are problems, therefore, in terms of effective operation and trying to get things within a remote, speedy time frame. Questions about where documents, including electronic documents, are held. We've debated that. It may be known. It may not be known. Indeed, at the time at which these sorts of notices are given, it's highly unlikely to be known. These notices are directed to individuals or to people, and they don't know where the documents are. There may be documents physically in the jurisdiction, there may be electronic documents held on servers here, there may be electronic documents held on servers abroad. But one simply doesn't know. More fundamentally, what about those states where there is no MLA agreement, where there is no MLA treaty, or where MLA requests are likely to take an age or to run into the sand? So of course they are available, and of course domestic legal powers have been put in place to enable them to be dealt with reciprocally. But there's a significant issue, a risk with undermining the effectiveness of investigations by the SFO if you treat MLAs as being the exclusive means by which you can access things. And as I say, take one example, take the UK-US MLA treaty, which, as the Divisional Court pointed out at paragraphs 87 to 89, was relevantly signed for the first time in 1994, after the 1987 Act was in force. But it's just simply an example. There are many countries in which an MLA agreement of this kind has not been formulated. And we do therefore submit, if you go back, if you would, to the judgment of paragraph 77 on page 140 of the electronic file, page 140, para 77, we do submit that that paragraph is correct and compelling in its analysis against any argument that MLA were intended by Parliament to be the exclusive way, so as to enable you to say, well, you don't need 2-3 at all. It's all about 2-3 must be very circumscribed. It's all about MLA whenever you're abroad, wherever you've got a foreign element. And read with those paragraphs, as I say, it's not directly relevant now because these grounds are no longer being pursued. But there is a chunk of the judgment which deals directly with MLA under the context of, under the heading of ground 2, discretion. And all of that analysis is helpful and useful for present purposes, for the purpose of knocking out this submission that MLA were intended to be exclusive. So we do recommend to the court that whole section from 85 to 86, 85 to 96 of the judgment, page 141 to 144, and in particular, the conclusions at 93 to 95.
I was wondering, Sir James, if the MLA route isn't exclusive, Why is there a difference in relation to the precautions that are put in place? Why did Parliament consider it necessary to put in place precautions so the documents, for instance, are returned in relation to MLAs, but not in relation to a Section 2.3 notice?
Well, my lord, there's no consideration of that in the pre-legislative materials in terms of the 1987 Act. So the short answer to that question is that we don't know, but there are restrictions on the manner in which documents can be handled, and there are restrictions on the manner in which documents can be retained that are provided for elsewhere in other parts of domestic law, including under data protection legislation and including under the broader powers under which the SFO operates. So my respectful submission is that you couldn't take from the introduction of specific safeguards a conclusion that Section 2.3 was, as it were, entirely Wild West territory. So the short answer is that there are some controls, but they may or may not be different to the express controls that are then introduced later by Parliament. And I don't know whether this is a good principled answer to that question. If I can just finish before coming to Lord Briggs, that Lord Stephen's question, but we also know that Parliament, as it were, reacts at certain points in history in different ways, and it drafts in different ways, and it confronts different issues in different ways. And it might be thought that if there is anything that is clear from this issues, particularly given the number of cases that have wended their weary way to this level of court, it is that the drafting position, the legislative techniques that are used, the existence of greater or lesser safeguards, the existence of particular forms of words or not, is not uniform in this context. That's why we're here. We're having a debate about that. We're having a debate about what it meant in 1987, principally. You cannot take, as it were, from this scheme, the sort of point that you can sometimes take from a legislative scheme or a set of pieces of legislation which were introduced either at a particular point in time or on the basis that there was a pretty well set of legislative assumptions. I was about to give an example of that, Carltona, and the way in which legislative techniques have developed in relation to that, in which it might be thought to have been understood that most of the time in which Parliament over the years had wanted to impose duties or functions on secretaries of state personally, and there are numerous examples of this, they had said it's a duty or a function conferred on the Secretary of State personally. That nowadays would be a slightly less certain example as a result of some of the analysis of the Supreme Court in the Adams case. But you get the point. This is an area in which, in terms of extraterritorial effect of different pieces of legislation and state powers, in which there is precious little uniformity. And so it's very dangerous, I submit, to start saying, well, they did that in that part of the world and they did something else in another part of the world. Oh, I'm sorry, I interrupted Lord Briggs's hand.
The mischief is obvious, as you've articulated. That is, how do you get documents from overseas? There are two methods of doing it. One is through MLAs and the other is through a Section 2.3 notice. One would have thought that if the MLAs was not exclusive, that you would have the similar protections in the 2.3 notice as you have under the MLAs. For instance, the returning of documents. So if it is exclusive, MLAs is exclusive, well, then you have the protections. Otherwise, the protections count for nothing. That's the difficulty I have at the moment, and I would be grateful for your assistance.
Well, my lord, the answer to that is the one that I gave, which is that you can't assume that there are no safeguards on the sorts of things that the specific legislative provisions that you referred to cover. There are safeguards which protect in the hands of lots of public authorities the way in which they deal with documents, including now under the HRA. But there always have been, and for many years have been, protections that are in place. What I quibble with, if I may respectfully say so, is the idea that because specific safeguards are introduced many years after the event in 1980, from 1987, you can in some way infer that their absence in 1987 in this specific piece of legislation or in relation to this specific power in some way informs the answer to the question, how broad is section 2.3?
I was wondering, Lord Panic, whether a possible, I mean, it may be comprised within the answer you've already given, but solution to Lord Stevens' conundrum is that where documents are extracted under compulsion from someone else, then in the private law context, disclosure in legal proceedings, there's an implied obligation only to use them for the purpose for which they've been obtained. And in the public law context, I wonder whether there wasn't a similar obligation in any event, even before one starts to look at the interstices of data protection and other express legislation that might have an impact.
My Lord, I'm
It wouldn't go as far necessarily as requiring their return, but in the context of electronic documents, there will probably be other copies still available abroad, and it would be sufficient if they were simply got rid of.
The public authority as a statutory and public authority performing public functions,
yes,
would undoubtedly be under purposive limitations in terms of its action.
yes. But that's what I had in mind.
That you indicate. Yeah, I agree. But there are, as I say, there are other legislative controls alongside that.
Mm. Thank you.
My lords, my lady, sufficient connection test. So far as that is concerned, my learned friend's case, as I've understood it, is that doesn't operate, can't operate. There is no jurisdiction, whatever the nature of the connection to the fraud, whatever the nature of the connection of the company in relation to those activities with this jurisdiction may be. You're simply left with foreign corporation as one of the conditions that knocks you out and that restricts the scope of the power to operate. The divisional court, as we know, held that there had to be some connection of the foreign company to this jurisdiction for the power not to be exorbitant. Our primary case, as you know, is that isn't necessary in any form, however you define sufficient connection, because the legislation was intended to be so broad. But even assuming that such a connection is required, if it is required, that then operates as a point thoroughly against my Lord Panic's more extreme version, which is mere fact of foreign incorporation, because you can then posit a series of factors of precisely the kind which the divisional court identified in this case as being present, in which the section 2.3 power would be thoroughly useful, if not more, to be exercised in order to understand lines of inquiry and conduct an effective investigation, but it simply couldn't be used, irrespective of the fact that there were a string of very serious and relevant connections between the company from whom you were requesting documentation and the investigation and all this jurisdiction. And so, to take a stark example, suppose you have a foreign company which is in effect operating a fraudulent activity through, or in part it appears factually controlling the activities of a subsidiary that happens to operate in the United Kingdom, e.g. by approving invoices that may be corrupt. Well, Lord Panic would say it doesn't matter. Hard luck. You can't go there. You can't understand whether they were cleared, why they were cleared, who cleared them. You can't do that, even though it would be possible, without breach of international law or comity, to prosecute the company and all the individuals abroad who were performing that directing activity. And my respectful submission is that that can't be right in principle. So if you get to a stage where, as the divisional court did, and indeed as we understand it in a slightly different context as the Privy Council did in the AWH decision, you get to a place where you demand some connection to the jurisdiction. The question then really becomes a definitional one of how you define the nature and extent of the connection, which is enough. Now, normally one would imagine courts being very alive to the myriad of different potential factual scenarios that might arise in future, would be cautious before setting absolute limits to a principle such as sufficient connection, and would tend to say that the principle is it all depends on the facts. But you would look for whatever connections there might be, and they may be corporate, although, as I indicated in the discussion with Lord Stevens and Lord Briggs earlier, that sort of connection of where your general business operates and is connected may have no bearing on how you are related to or connected with the fraud. So my submission was that it should be more connected with the fraud than less. My Lord, sorry, Lord Hamlin, yeah. I think someone might need to unmute Lord Hamlin, otherwise unable to speak or demand to be unmuted.
Can you hear me?
Yes, I can. Thank you, my Lord.
So on your case, is there any extraterritorial limitation on the power under Section 2.3? If so, what is it?
My Lord, we accept and are recorded as having accepted in the divisional court that the notice has to be given to someone here. But beyond that...
But why on your case does that have to be so?
Well, it provides a connection with the jurisdiction. And I see the force of the point that says the logic of it may tend to an even broader position. But we are in that happy factual state. But my submission is that the Parliament deliberately intended this to be broad. And if you're going to introduce limitations, one can, as I say, understand limitations that are based on Parliament being presumed to have legislated in relation to this sort of power in conformity with international law. But that's back to international law versus international comity and the controls that they impose. But subject to that, it's a very broad jurisdiction, we respectfully submit. My Lord, my Lady, I was making the submission, if only to finalise this point, that the divisional court we respectfully submit were entitled both to approach the matter the way they did and to find on the facts that there was sufficient connection here. For the reasons they gave, we've summarised that in our case at paragraph 58, giving you the various paragraphs in the divisional court judgment there, I hope. And so we submit that if you are in a place where a sufficient connection is the test, that approach and those facts we submit are made out. My Lord, my Lady, those were my submissions. Can I just check? I'm being communicated with by email. Would you give me 20 seconds just to email so that I don't have some horrific email that says, why on earth did you say that? My Lord, my Lady, I think nothing I feel the strong urge to put before you.
Thank you.
Those are my submissions.
I don't think there are any questions for Sir James. No, thank you very much. Okay.
I'm unmuted. I hope you can hear me, my lords, my lady. Can I deal first with Sir James's heavy reliance on my acceptance this morning that the presumption is based on international comity and not on international law as it would be accurately defined by an international lawyer. And my friend relies, for the purpose of distinguishing the Perry case, on what was said by Lord Phillips at paragraph 94. Could we please go back to page 603, where Lord Phillips does indeed refer to international law in the fifth line. My submission is that the principle which Lord Phillips articulates is not a principle which is based on international law properly defined. And that is because the principle is set out in the seventh line. Section 357, read with section 359, does not simply make proscribed conduct a criminal offence. It confers on the public authority the power to impose on persons positive obligations to provide information subject to criminal sanction in the event of non-compliance. To confer such authority in respect of persons outside the jurisdiction would be a particularly startling breach of international law. In my submission, Lord Phillips refers to no specific provision of international law properly defined, and the description of that which would be particularly startling does not depend on international law properly defined. It depends upon the presumption which is well established in the authorities that I've taken the court to, and which Sir James did not address. I don't criticise him for not doing so because they are so well established. That is Alskaney and Masri. That is what Lord Phillips, in my submission, is talking about. He's not talking about some special provision that would be understood by an international lawyer as established in some treaty or in some statement of the International Court of Justice, or even in customary international law. It's a principle based upon a well-established presumption. Now, my lady, Lady Arden, asked the question whether the court can act by reference to comity. And I emphasise, I'm not asking the court directly to implement or even to interpret the principles of international comity. I simply rely on comity as the explanation for the principle which is stated by Lord Phillips in Perry, and which is the basis of the presumption upon which that statement is based. And I also rely on international comity because I say that it provides the explanation as to why Parliament has consistently proceeded on the basis that the provision of information abroad to criminal investigating authorities here should be carried out through cooperation with the authorities of the relevant international state. Parliament has so proceeded not because it must under international law, but because it has chosen to do so, no doubt for very good reason. And I say, for the reasons I gave in opening, that provides the context of section 2, subsection 3, and it informs the meaning of section 2, subsection 3. So, my lords, my lady, I do not accept, with great respect, that Perry is distinguishable. The principle that is stated by Lord Phillips in the third sentence of paragraph 94 is a principle concerned with compliance Section 357 authorises orders for requests for information with which the recipient is obliged to comply. And it is compliance which is the relevant factor. It is nothing to the point that the notice was served on a representative of the company in this jurisdiction. What the notice requires in relevant respects is compliance abroad by a foreign corporation which does not have a place of business in this country. Indeed, taking up the point made by Lord Briggs, is not managed in this country. So it doesn't help the SFO that the notice was given here. Compliance is the relevant factor for the purposes of the presumption and for the purposes of international comity. If it matters, and I don't accept that it does, your lordships, your ladyship will have noticed that the section 2.3 notice was only able to be served on the appellant's representative in this jurisdiction because of her temporary presence at the request of the SFO to discuss the provision of information. See paragraphs 5 to 9 of the agreed statement of facts and issues, page 54. Perhaps we should just go to that. Page 54 of the agreed statement of facts and issues. Paragraph 5 deals with the fact that this is page 54, we had supplied material, but not material in the United States. Paragraph 6, a meeting was offered with the SFO in London to discuss the investigation. At the insistence of the SFO, representatives of the appellant agreed to attend. My friend has referred to a number of paragraphs in the judgment of the Divisional Court. Paragraph 100 of the Divisional Court judgment, page 145, says, I quote, "There are unappealing features of the SFO's decision to give the July notice to Miss Ackerson in the course of attending a meeting to discuss the investigation." If relevant, I would use rather stronger language. But in any event, I say that it is highly unlikely that Parliament can have intended by section 2, subsection 3, to impose an obligation on a foreign corporation with no place of business in this country, not managed in this country, in respect of documents held abroad, on pain of criminal sanctions, only because of the happenstance that the foreign corporation's officer is temporarily in this jurisdiction at the insistence, that's the word used, the insistence of the SFO. Sir James emphasised in his submissions the strong public interest in investigating crime. I addressed this in my opening, and I accepted that there is, of course, a strong interest, but the question, the legal question for this court is how Parliament intended this public interest to be advanced. And I've made my submissions, I won't repeat them, that Parliament intended that public interest to be advanced, and I will submit in a moment, only advanced through international cooperation. My lords, my lady, if public interest were the answer to this case, the Perry decision would have been very different. And indeed, that is addressed in his supporting judgment by Lord Justice Hughes, as he then was. The judgment of Lord Justice Hughes agreeing with Lord Phillips begins at page 616, the bottom of page 616, And Lord Hughes adds at page 617, paragraph 156, these words, if your lordships, your ladyships have it, 617, for my part, if it were possible to construe the complex provisions of the Act in such a way as to admit of limited extraterritorial effect for Part 5, but only where there is a sufficient jurisdictional connection between a part of the UK and the criminal proceeds, I should have wished to do so. I am, however, reluctantly persuaded this cannot be achieved by construction and would involve illegitimately rewriting the statute. In my submission to introduce a substantial connection test into section 2, subsection 3, would, with great respect, be legislation rather than interpretation. Sir James made a powerful submission that the statutory provisions in relation to MLAs are permissive. We respectfully disagree, because the consistent approach of Parliament, most recently in the reversal of the Perry decision, the consistent approach of Parliament has been to deal with this sensitive issue of obtaining documents, information from abroad through international cooperation. And that is precisely because of the presumption, because of international comity, and because of the international sensitivity of the authorities of this country issuing demands on foreign corporations backed by criminal sanctions. And this is precisely why, as I showed the court, Parliament has expressly recognised the SFO as a designated authority under those statutes with a specific power to seek international cooperation. And I do rely on the point which my Lord Stevens put to my friend. I do rely on the point that when Parliament has acted in this context, it has imposed restrictions, it has imposed safeguards. And the reason it has done so, in my submission, is because Parliament recognises the sensitivity of this matter. And I say that it is exceptionally unlikely that by section 2, subsection 3, Parliament intended to confer on the SFO a discretionary power which is not subject to the restrictions and safeguards that your lordships, your ladyships have seen in the other legislation. My Lord Briggs suggested that such safeguards may be implicit. In my submission, it would be very surprising indeed if Parliament had left such important matters to implication when it has expressly addressed them, and understandably so, in the later legislation. I should also mention, although I don't invite your lordships to turn it up, that there is a valuable judgment in the Court of Appeal in the case of Gohill, Gohil, by Lord Dyson, Master of the Rolls for the Court of Appeal. It's at page 1174, and in it, his lordship addresses at paragraphs 12 to 20 the history of MLAs. And I draw attention to it because I invite the court, when it considers these matters, to look at paragraph 19, which is on page 1180, at the end of which Lord Dyson says, I quote, "These restrictions on collateral use of evidence provided by one state to another are necessary to ensure that the scheme of international mutual assistance in criminal matters works effectively. And we respectfully adopt that approach. And therefore, what I say, it is no answer for Sir James to say that MLAs in principle do not limit the power to obtain information in any other way. Yes, in principle, but that assumes the very question that we are debating today, which is, did Parliament intend that Section 2, subsection 3 should be another means of obtaining information abroad? My friend relied also, I think this is the final point, he relied on the OECD provisions. The answer to that, we have the OECD provisions in the bundle at page 358. If I could invite your lordship's attention to the OECD provisions, it starts at page 354. At 358, Article 5 says investigation and prosecution of the bribery of a foreign public official shall be subject to the applicable rules and principles of each state. And Lord Bingham, for the appellate committee, in the Corner House case, emphasised that this conferred a broad discretion on each state. See Corner House, which is in the authorities. I won't take time on it, but it's at page 1418, paragraph 46. And of course, as Sir James himself often reminds this court should be very slow indeed to interpret international agreements, international provisions of that sort. In any event, if one turns over electronically to page 359, Article 9 refers to mutual legal assistance as an important way of implementing the obligations. Sir James referred to substantial connection test, and I've shown your lordship's Lord Justice Hughes' observations. I say, in any event, none of the factors to which Sir James refers alters the central facts of this case. The documents are held abroad by a foreign corporation which does not conduct business in this jurisdiction and indeed is not managed in this jurisdiction. For those reasons, I say in response to Sir James's submission that Section 2.3 does not apply. We invite this court to allow this appeal. Those are my submissions in reply, subject, of course, to any further matters I can seek to assist on.
Thank you, Lord Panic. I don't think there are any questions for you. No? There we are. Well, we're very grateful to all counsel in the matter for their very helpful and clear submissions. And very grateful too to all those who metaphorically sit behind you for the preparation of the case. We're going to take some time to consider the matter and deliver our judgment in due course. Thank you very much indeed.
Thank you.